Good morning, everyone. I'm very pleased that so many of you are here. So far, at least, it seems that the vast majority of employees are being very supportive of their employers. They're being sensible about agreeing to go on furlough or work different hours or different duties. But there will be some who, for a variety of reasons, will be using their time on furlough to set up in competition. There'll be some who feel undervalued because they've been chosen for furlough. There'll be others who worry about redundancies and think that their future is safer in their own hands. And there will be others who spot a new opportunity as the world adopts new ways of working. And perhaps there'll be yet others who cynically will jump on the opportunity to work for themselves while being paid by their employer. So one of the things that employers may want to be thinking about is how best to deal with the threat of employees using their time on furlough to set up in competition with their employer. And that's what I want to talk about today. I'm going to try and cover these questions. What is furlough? What duties do employees owe when on furlough? How far can employees go in preparing to compete without breaching the implied duty of fidelity? What remedies are available? And how can employers discover and prove unlawful activity? Let's get started with the first question. What is furlough? Now, I confess that until recently it was a word I knew only from US prison dramas. I think now we all know what it means. The important point, though, so far as we're concerned, is that the coronavirus job retention scheme is a fiscal scheme. The rules regulate the relationship between the employer and the state. They don't directly regulate the relationship between the employer and the employee. So long as the employee agrees not to work during the furlough period, employers and employees are free to agree amongst themselves the necessary amendments to the employment contract. That said, I understand that most employers and employees have agreed relatively straightforward, standard form terms where the employee agrees not to work, but that otherwise the same contractual terms will apply. And so for our purposes, we've got something that looks very much like garden leave. Because of the close analogy with garden leave, we can identify with confidence the duties that employees will owe when on furlough. There's two categories of duties that all employees will owe. All employees will owe express duties, and they will vary, of course, and they'll depend not only on the terms of the individual employment contract, but also on the terms of the furlough agreement. All employees will also owe implied duties, and in particular, the implied duty of fidelity. There's two categories of duties that only some employees will owe. Some employees will owe fiduciary duties as employees, narrower or broader in their scope and dependent on the terms of the employment contract. And some employees will be directors and owe duties under the Companies Act 2006. Now, all of those duties will affect what an employee can and cannot do in preparing to compete while on furlough. But the one that's most instructive, the one that I want to concentrate on for today, is the implied duty of fidelity. What is the implied duty of fidelity? Well, it's a duty that's somewhat hard to pin down. In a recent Court of Appeal case, Lord Justice Lewison described it as an obligation loyally to carry out the job that the employee agreed to do. That's a very broad description, and that's because the duty is broad. It has positive aspects and negative aspects. It means that the employee must do certain things and must not do others. We can concentrate on the negative aspects, and they cover a wide range of activity. It will, at least sometimes, be a breach of duty for an employee to copy, memorize, or misuse confidential information, to recruit co-workers, to divert business opportunities, and to engage in competition. And during this talk, I want to pin down a little more closely what will and what will not reach the negative parts of that duty. Now, I said earlier that we could be confident what duties apply during furlough because furlough is so similar to garden leave. We can also be confident that the implied duty of fidelity will apply in the same way. The implied duty of fidelity is a duty which depends on the context, but in garden leave, the implied duty of fidelity applies just as it does during the ordinary course of employment. And I think we can safely say that the same will be true of furlough. In a garden leave case, Mr. Justice Popperwell in the Blue Bay case said that the implied duty of fidelity applies just as it does during employment, the negative parts of the duty do, because the employer is paying for the continued right to insist on the employee performing his negative obligations. And the same principle will be applied during furlough. The employee is still being paid by their employer and will be expected to abide by the same restrictions. So we get on to the tricky question for today. The negative parts of the duty will apply, but how do they restrict what an employee can do? Or turning the question around, how far can an employee go in preparing to compete without crossing the boundary and breaching the implied duty of fidelity? And for the next 10-15 minutes or so, I want to try to discuss that question. Let me start with the law as it was often described until about 15 years ago. It was often said that there was a distinction to be drawn between merely preparatory activity and actual competition. Merely preparatory activity was lawful, actual competition was not, it was thought. And so there were cases suggesting that identifying suitable premises, negotiating a lease, incorporating a company were all okay. That was merely preparatory activity. But actual competitive trading, competitive tendering, competing for equipment and staff were not. That was actual competition. That changed with two decisions in 2006. The first was a decision of Mr. Justice Etherton in a case called Shepherd Investments and Walters, and a second was the decision of the Court of Appeal in the landmark case Helmet, Integrated Systems and Tunnard. Both those cases, the court emphasised that merely preparatory activity could constitute a breach of the implied duty of fidelity. Now, before we discuss the law in any detail, I wondered whether you could guess how the courts decided the two cases if I told you the basic facts. And I'll put a Q&A on the screen in a moment. Let me start with Shepherd Investment and Walters. Shepherd Investments was an investment fund where clients invested in fractionalized life insurance policies. The defendants in the case were 4 senior employees, the heads of finance, sales and investment, effectively. And when the founder of the company moved abroad, those 4 senior employees decided to run a company, running an investment fund, investing in whole life insurance policies. Now, you don't need to know the difference between a fractionalized and a whole life insurance policy. The judge found they were competitive. What did they do? Well, before they resigned, the 4 employees consulted Cayman Island attorneys, and those attorneys drafted a raft of documents, an offering memorandum, an escrow agreement, an administration agreement, custodian agreement, an investment advisory agreement, and a memorandum and articles of association. Now, I'm interested, before we get to the detail of the law, for your reactions, instinctive as they may be. Does this feel like a breach of the duty of loyalty? Does this feel like disloyal behaviour which ought to be a breach of contract? 75% of you think that that was a breach of the implied duty of loyalty. And I can tell you that Mr. Justice Etherton found the same way. He found that the employees were in breach of their duty of fidelity. Now, before I tell you why that was, I want to share with you the facts of the next case, and I'm interested in your reactions to this. What about Helmet Integrated Systems and Tunnard? The employer in that case made helmets for firefighting. That's a picture of the helmet they made. It was called the F800. And there was one relevant employee, Mr. Tunnard, a middle-ranking sales manager. And he saw an opportunity to design a new helmet for the fire service. He called it the Targa helmet. Again, there's a picture of it. Again, you don't need to understand the differences between the two products. The important thing is that the judge found that they were competitive. Before he resigned, Mr. Tunnard consulted an industrial designer. So the employees in Shepherd Investments consulted an attorney, Mr. Tunnard consulted an industrial designer, and the designer prepared concept drawings and a project plan. So what do you think? Again, I'm just interested in your instinctive reactions at this stage. What do you think of this case? Do you think this crossed the line? Was this a breach of contract? 53% of you think that that was a breach of contract. So very, very evenly split. And that doesn't surprise me at all. You might be interested to know that the first instance judge in this case found that there was a breach of contract, but the Court of Appeal found that there was no breach of contract. All of you voting have some judicial support at least. We get different outcomes. Shepherd Investments, the employees found to be in breach of duty. Tunnard, the employee, not found to be in breach of duties. What was the difference between the two cases? At first blush, they looked very similar. The employees at each case had reached a similar stage of preparation on a competitive product. They'd both, in their own ways, worked up a detailed design for their respective product. So why were the employees in Shepherd Investments in breach of duty, and why was Mr. Tunnard not? I think essentially there were three main differences. One really important difference was that in Shepherd Investment there were 4 employees acting in concert, but in Tunnard just 1 employee. And that's important because it's one thing to contemplate leaving your employment yourself. The law's never going to prohibit that. But it's quite another to encourage others to leave. And if you're working up a plan in concert with others, you're necessarily encouraging others to leave. And there's a linked point. Sometimes a senior employee will have a duty to disclose a competitive threat to his employer's business. The courts have been very reluctant to imply a term into an employment contract, requiring an employee to disclose his own competitive plans, his own competitive thoughts. The first instance judge in Tunnard thought that that would be Orwellian. I think that might be taking it a little too far. But the important point is this: the courts have much less difficulty with implying an obligation on senior employees to grass up their colleagues. And so if you're a senior employee working in concert with others, you may also be breaching your duty by not disclosing the competitive plans of your colleagues. That's the first important difference. The next important difference concerned the employees' roles. In Shepherd Investments, the employees were doing the sorts of things that they might be expected to do for their employer. But in Tunnard, the employee was doing something completely different. His job had been to sell helmets, and it had never been part of his job to design a helmet. And the Court of Appeal thought that that was important. They emphasised that Mr. Tunnard wasn't a director. Director would owe a duty of single-minded loyalty. Mr. Tunnard was an employee, and his duty of loyalty was a duty to do the job he was employed to do. And designing helmets wasn't part of his job. And so the Court of Appeal thought the duty of fidelity, the negative parts of the duty, were coloured by the positive parts. Because he was no part of his job to design a helmet for his employer, they thought designing his own helmet wasn't a breach of the duty of loyalty. The third difference between the cases was seniority. And it follows perhaps from the second difference. Mr. Tunnard's responsibilities were more limited because he was more junior, and therefore what amounted to a breach was more limited. That was an important difference. It did feature in the cases, but I'd say out of the three differences we've identified, it was the least important of the three. And I think there is a tendency in this sort of litigation to overemphasize the importance of seniority. Seniority can be misleading because employees can have rather grand job titles, very big salaries, but very specific responsibilities. So we can translate these three differences that we've identified between those cases into three questions you might ask when trying to decide whether an employee has crossed the line in his preparatory activity. Question one, is the employee acting in concert with co-workers? If the answer to that is yes, the employee has probably crossed the line. If not, then we want to look at these two questions. Most importantly, how close is the preparatory activity to the employee's duties? And then, how senior is the employee? I thought it would be good to mention one more case as an illustration of these principles. That's the case of Customer Systems and Ranson, a Court of Appeal case from 2012. Mr. Ranson was a salesman at an IT company. Just before he resigned, he incorporated his own company and he registered a domain name. And then literally days before he resigned, he approached two customers. The first of those was Mr. Clothier. And the trial judge found that Mr. Ranson had tried to solicit specific business from Mr. Clothier. And the judge found that Mr. Ranson had breached his implied duty of fidelity. But the Court of Appeal disagreed. The Court of Appeal emphasised the importance of looking closely at the individual employee's responsibilities. And the trial judge had made quite detailed findings of fact about this. He'd looked at Mr. Ranson's employment contract and at Mr. Ranson's annual appraisals and found that Mr. Clothier wasn't somebody who Mr. Ranson was expected to win business from. He wasn't, as the judge put it, on Mr. Ranson's patch. And the Court of Appeal said, well, the result of this, if Mr. Clothier isn't somebody that Mr. Ranson is expected to sell to on behalf of his employer, then it's not a breach of duty for him to try to sell to Mr. Clothier himself. The second customer Mr. Ranson approached was a Mr. Boardman. Now, Mr. Boardman was on Mr. Ranson's patch. But the important finding of fact was the trial judge's finding that Mr. Ranson had not expressly discussed any particular business with Mr. Boardman. The judge found that Mr. Ranson had taken Mr. Boardman out for dinner and what the judge described as an alcoholic evening. And the trial judge thought that this was a breach of the implied duty of fidelity. it was wrong to attempt to smooth Mr. Boardman just 2 days before leaving his employment. But the Court of Appeal said this wasn't a breach of the duty of fidelity. The Court of Appeal said there was nothing wrong with paving the way for future business by being friendly and attentive to customers in the hope that you might later win their business, even if it is 2 days before you resign. I think this is a good illustration of how closely you have to look at the employee's duties in order to work out what will amount to a breach of the implied duty of fidelity and what will not. If we draw these strands together, I think we can start off with things that will not be a breach of the implied duty. It's going to very rarely be a breach of the implied duty to incorporate a company, old case law tells us that, or to register a domain name, or to consult friends and family, so long as they're not co-workers, or to identify and rent premises. There will be things which will almost always be a breach of duty, things that do direct and immediate harm to your employer. Copying or deliberately memorizing confidential information, poaching employees, starting work for a third-party competitor. And then we get the more difficult cases, where, as we've seen, you need to look at these three things. First, is the employee acting in concert with co-workers? If so, strong case of breach. If not, then you need to look very carefully at what the employee's duties are. That might involve going beyond the employment contract and looking, like the Court of Appeal did in the Ranson case, at performance appraisals, annual reviews. And then looking at the employee's duties, taking into account their seniority, consider how close the preparatory activity is to the employee's duties. I just want to look briefly at three remedies that are available. I'm not going to deal with this in any great detail because it would be easy to have a talk for half an hour or so on each of the three remedies that I'm going to speak about, but just let me mention three. Firstly, most obviously, compensation. That's not always a very attractive remedy. It can be difficult to assess the loss suffered by an employer if an employee breaches his duty of fidelity by preparing to compete unlawfully during employment. And it can take a very long time to pursue a case to get an award of damages. More attractive is a prohibitory injunction. If you catch an employee while they're still employed, you may be able to get a court order stopping the unlawful activity for the remainder of the employment. But if the employee is already left, or the employee can leave without giving much notice, a prohibitory injunction can sometimes not be much use, because a prohibitory injunction only enforces obligations while the obligations themselves, the contractual obligations, are in force. Once an employee leaves employment, his or her implied duty of fidelity ceases. So unless the employee has agreed restrictive covenants, there's then nothing for the employer to enforce by a prohibitory injunction. And in those circumstances, the employer needs something else. Very often that something else is a springboard injunction. And that's going to be, I would think, the most attractive remedy in this sort of case. Because you can get a springboard injunction once the horse has bolted. Once the employee has already left and started up in competition, so long as you act urgently and so long as the conditions for making an order are met, you can get a springboard injunction. Now, the idea of a springboard injunction is to undo the competitive advantage that the employee has gained by their unlawful activity. So the court might decide, for instance, that a particular employee has got a 2-month head start by starting up employment, by starting a competitive business while still in employment. And they might, in respect of that 2-month head start, grant an injunction preventing the employee undertaking any competitive activity for 2 months. And the idea then is they take away the head start, take away the advantage, the springboard the employee has gained by the unlawful activity. That's a very powerful remedy. It's a very useful remedy. It is also a flexible remedy. And it strikes me that in the circumstances we all face now, the judges may need to adjust this remedy. I can see a judge saying in a particular case that an employee has got a head start equivalent to 8 weeks in lockdown or 4 weeks during ordinary times, and then adjusting the order accordingly. How do employers discover and prove unlawful activity? Now, very often when I'm talking about this sort of subject, I mention how useful forensic IT experts can be. And I've been very impressed by how they can find fingerprints of wrongdoing in all sorts of places. But while it's certainly still worth considering engaging forensic IT experts, I think that they are unlikely to be as useful in the current times because so many employees will be working from home. Now, if we look at a list of possible sources of information, employees aren't going to be using printers. If they're working from home, they're not going to be using the company printers. They're not going to be leaving a trace on the company firewall. They're not going to be fobbing in and out at unusual times, one would expect. The employer may find it more difficult to get hold of their laptop or their mobile. There may be less activity on the file server. Still might find something on the email server, but employees are generally pretty sensible about not leaving traces of of their competitive plans, at least in outgoing emails. You still might find the employee has access to the cloud, but it may be more difficult to distinguish between legitimate and illegitimate uses of the cloud. The old excuse that the employee had to download rafts of sensitive, confidential information in order to work at them at home on a spotty internet connection suddenly seems more plausible. And with telephone logs, you're not going to find anything on the landline logs. If the employee uses a company mobile phone, then you might see some interesting entries in the itemized billing, but equally it would be very easy for an employee to be using their personal phone a lot. So if forensic IT evidence isn't going to be as useful as it usually is, then what are employers to do? How are employers to discover and prove unlawful activity during furlough? I think that all this means that gathering information from human sources is all the more important, particularly employees and customers. Now, I know that managers are already being encouraged to speak regularly, one-on-one with employees for all sorts of reasons. Discovering competitive activity is another. The more contact business owners and senior managers have with employees, including furlough, and particularly the more one-on-one contact business owners have with employees, the more likely they are to discover a competitive threat. And the more likely they are to get copies of WhatsApp messages and the like, which will allow them to prove the competitive threat. Now, the same could be said for customers. Apart from the other good reasons for doing so, having senior people contact important customers is going to be a very good way of discovering competitive threats.